always note the date of the test. The date of the test differs from the course outline. It's not on Tuesday, it is on Thursday. I don't know why I said Tuesday on the course outline. It was always supposed to be on Thursday because it is literally written in your class time during your scheduled lecture time. Scheduled lecture starts at 6:30 till 8. The test starts at 7 o'clock in Auditorium North, the venue that was reserved for you for face-to-face classes, although we aren't having face-to-face classes. So just make a note of that so that you don't rock up at the venue on Tuesday, because then you won't find me there. Then, and I have explained this before, there is an additional test, an optional test opportunity available on Saturday morning at the regional centers, not in Windhoek. If you don't come and write on Thursday, if you live in Windhoek and you don't come and write on Thursday evening, then that's very sad, but then you've missed the test. And you don't get the marks. They have to write the makeup test, which covers all the work we've done in the semester. So don't postpone for the makeup test. Makeup test is also face-to-face. That's a lot more difficult. So come and write on Thursday. The reason why there is the test opportunity on Saturday morning, and this is actually already during recess. Friday is the last day of lectures before recess starts. Is because the test is from 7 p.m. to 8 p.m. during class time. But there are students that are registered for part-time mode that live in the regions, but that do not live close to the regional centers, that have to travel to the regional centers, often quite some distance. To accommodate them, and only them, so that they don't have to travel back home and drive for an hour or two after 8 o'clock in the evening, there will be a test opportunity available for them on Saturday morning. That test is only available at the regional centers. It is not available in Windhoek. That is not negotiable. Don't come and ask me if you may write on Saturday if you live in Windhoek, because the answer will be no. Let me share my screen quickly. Okay, thumbs up quickly if you can see the screen. Thank you, Mr. Lissa. Thank you, Queen, Asser, Narisha. All the same faces, same names, same people to Snelda. I appreciate all of you. I find it very interesting, though, that there are 120 students registered for part-time, and only on the average of 20 students attend class. Always the same people. I appreciate you. Where's the rest of them? And then just another quick, yes, Narisha?
Good evening, Ms. Hanakom. Thank you very much for presenting the class so perfect and so well presented. A question that I've wanted to ask: the attendance in on the live sessions, isn't it compulsory as well?
In terms of the academic rules, Sorry, I've just got something in my throat. Give me a second. Students are expected to attend 80% of the classes. With regard to introduction to law for accountants, because there's no separate distance mode, everybody is registered either full-time or part-time. There are students that would, if distance mode was available, would have registered for distance and would have preferred to have classes maybe on a Saturday because they work in the evenings, etc., etc. So I cannot, and you don't get marks for class attendance. I cannot make class attendance compulsory because there are students that cannot attend class. I don't think, as I've just said, there's an average of 20 students that attend, including you regularly. Out of 120, I don't honestly believe that 100 of them work in the evenings and can't attend class. But I have to treat you like the mature students that you are. This might be your first year at NUST. If I look at your student number, it's 22600. It means this is your first year of registration at NUST. Mr. Lisso, also first year of registration. Mr. Awala, Mr. Kluter, all 2026 registrations. But you are not school leavers. You might have only started studying this year, but you didn't do grade 11 or grade 12 last year. You are mature people, and I like to treat you like mature people, which is why the classes are recorded and the recordings are available for students that could not attend class to listen to the recordings at their own time. And of course, for those that did attend class that want to listen to them again to refresh their memories, the recordings are available. So yes, but I appreciate those that do attend class, because even though it's not, online will never be the same as face-to-face. I can't see your facial expressions, but at least I can sort of communicate with you. You can ask me questions at the time. If you're not sure of something, or you've got a question, raise your hand. You can ask me immediately, which you can't do if you're just listening to a recording. So yes, please do attend class if you can. Something else that I wanted to mention is, please do not private message me unless it is a private issue. Now, if you want to send me a private message saying, ma'am, I'm going to miss your class tonight because I'm really not well or whatever, then by all means, send me a private message. But if you're asking for notes or test dates or general queries, don't private message me. Ask on the group. I will not be responding to private messages. You know, I teach so many students. If I've got to respond to each and every private message, I would do nothing other than sit and respond to messages. So I'm not going to be responding to private messages unless it is something that's really private that you didn't want to share on the group that I can understand. But if it's work related or just general admin, please use the group. That's why we have the group. But okay, let's get started. We're busy with the contract of purchase and sale. We've learned contract of purchase and sale, a mutual contract for the transfer of possession of a thing in exchange for a price. In order for a contract to be a contract of purchase and sale, it must be valid. Everything we've done so far, units 1 to 7, basic requirements for contracts, you must remember, don't forget about them. Then the agreement to buy and sell, there must be a thing, and there must be a purchase price. Once a contract has these requirements, and it fits into the box called contract of purchase and sale. There are certain implied terms, natural legal consequences that will always apply. It applies to each and every contract of purchase and sale by law, unless you have specifically excluded them. Some of these natural legal consequences include the duties of the seller. So we're looking at the duties of the seller. First duty we saw is the duty to deliver the thing. Remember, delivery, not the same as we understand the ordinary English word, doesn't mean the seller has to take it to the premises of the purchaser. It means the seller must make the thing available so that the purchaser can take free possession of the thing. Then, second duty, the duty to guarantee against eviction. We've learned, and you were surprised to find this out, that you don't, as a seller, have to be the owner of the thing sold, because it's not a contract for the transfer of ownership, but a contract for the transfer of possession. If you aren't the owner, it can still be a valid contract of purchase and sale, but the purchaser will not become the owner because you cannot transfer more rights than you have yourself. But to protect purchasers in the event of the seller not being the owner, there is in every contract of purchase and sale a tacit, silent guarantee against eviction, where the seller undertakes to give the purchaser undisturbed possession of the thing. He guarantees that nobody with a better right will take the thing away, that the purchaser will not be evicted. Then in the last lecture, we looked at the duty to keep the thing in safe custody. I pointed out to you that this duty is only relevant if contracting and delivery are not simultaneous. If you've walked into the shop to buy a loaf of bread and you walk out of the shop with a loaf of bread, the duty to keep the thing in safe custody is not relevant. Duty to keep the thing in safe custody, if you buy it from me now, but we agree you will collect it or take delivery at the end of the month. In the in-between time, as seller, I have to keep the thing in safe custody. But then there is this odd thing of purchase and sale, which applies only to purchase and sale, not to lease agreements or barter agreements or loan agreements or anything. This is unique to purchase and sale, that once the contract is perfecta or complete, so the price has been fixed, the thing has been specified, and there are no suspensive conditions. Contract is perfecta and the risk passes to the purchaser. So if the thing is damaged or destroyed due to circumstances beyond the control of the parties, the purchaser is still legally liable for the full purchase price. Then our next rule, the last duty that we are looking at, is the duty to guarantee latent defects. This duty becomes relevant if the thing bought, the thing purchased, has a defect that existed at the time or prior to the time of contracting. So what is a latent defect? What is the requirements for a defect to be described? Sorry, I didn't want to do that. For a defect to be described as a latent defect, you need to know these requirements. First of all, it must have existed at the time of contracting. So we're not talking about damage that happened afterwards. We're talking about when you bought the thing, it was damaged. So we're talking about the instance where I've sold my car to Snelda and she's taken delivery, and once she's taken delivery, she realizes, but the engine block is cracked or the radiator doesn't work. So it existed before or at the time. We are not, remember people, we are not talking about damage that happened after contracting. We're talking about a defect that existed at the time of contracting. It renders the thing less useful or effective. So if I sold my cell phone to Narisha and she takes delivery of it, and once she's taken delivery, she realizes that the battery doesn't charge, that would be a latent defect. If, however, she takes delivery and she sees there's a crack in the screen, that is not a latent defect, because a slightly cracked screen doesn't make it less useful. It's still a phone. She can still use it. We're not talking about any itsy bitsy little thing that's not perfect. It must be so serious that a reasonable person not have bought it or not paid the same price. So we're not just talking about something that annoys you a little bit that isn't perfect. We're talking about a defect that makes it less effective. If you'd known, you would not have bought the thing. It is not visible. By the precise person. So a cracked cell phone screen is not a latent defect. When you buy something, you still have the duty as a reasonable purchaser to inspect the thing that you bought. So a latent defect, a defect that you would not have been able to pick up by doing a reasonable, a proper inspection. Buying a car, a problem with a radiator, it's not immediately visible. On the other hand, a scratch on the back door is not a latent defect. And not known by the purchaser. If you know the thing is defective, obviously you don't have a claim afterwards. In order to rely on the guarantee against latent defects, the purchaser has to prove that it was a latent defect. You have to prove these 5 requirements. If you can't prove one or more of them, you will not have be protected. The duty to prove is always on the purchaser. So you have to prove that this defect existed at the time of sale. The purchaser must do a proper inspection. But if you can prove that there is a latent defect, you will have a claim against the purchaser. Latent, to have the guarantee, it must be a latent defect. Must distinguish between a latent defect and a patent defect. A patent defect, that's a cracked cell phone screen or car tires that are worn, something that you could pick up with a reasonable inspection. So I'm just checking my notes here. I just want to make sure that I don't miss everything. If I can give you just some hints here. I've said this before. These notes of mine, and I will be sharing with them with you shortly, in good time still before the test. They don't replace the actual class notes. And on page 49, there's an example on page 49 that you will do well to read through that example. It's an actual court case regarding latent defects and when the purchaser will have a claim or not. That particular example is not actually in your test, but it will definitely be in your exam. So read through that, make a note of it for exam. You must always listen to me carefully. I give a lot of things away while I'm teaching. Now, I'm going to jump around a little bit in the notes. I should revise my notes. Doesn't make sense, but the sequence is a bit confusing. So if there is a latent defect, now all these other duties that we've looked at so far, we saw if the duty to deliver, if the seller does not deliver, it's breach of contract, the normal contractual remedies will apply. Similarly, if the purchaser is evicted, breach of contract, normal remedies will apply. Now, the guarantee against latent defects, it is a duty of the purchaser to guarantee against latent defects. But the remedies for a breach of this particular duty differ slightly from your normal contractual remedies. There are 3 possible remedies. That are not always available. And make sure that you understand these 3 different remedies and when they are available. So if I give you a question, an assessment question about based on the remedy of the guarantee against latent defects, don't give me, and I'm asking you what remedies are available. Don't just say all three of them, because you can lose marks if you refer to the wrong, the incorrect remedies. There are three possible remedies which are available only under certain circumstances. The first one is a claim for damages. Now, in this regard, the guarantee against latent defects differs from your normal breach of contract. I have previously told you or taught you that if there's breach of contract and you can prove those 5 requirements to prove your damages, you claim for damages will always be available. That is not the case in a claim based against the guarantee against latent defects. Claim for damages is only available in certain fairly limited circumstances. So you cannot always claim damages. When is it available? If the seller oops, bad typing. If the seller is a merchant or a manufacturer, somebody that is in the business of selling things. If I sell my cell phone to Narisha, I am not a merchant. I'm a lecturer. Doesn't mean I can't sell things, but I don't earn my income. I'm not a professional person that sells things. Merchants or manufacturers, people that's shopkeepers, people that make things and sell them, are held to a higher, because this is their business, they are held to a higher standard than ordinary people that just sell something on a once-off basis. So if you bought something from a shop and it has a latent defect, you will always have a claim for damages. If you buy it from me, not necessarily. If the seller gave an express guarantee, remember this guarantee that we're talking about now is a tacit guarantee, a silent guarantee. Let's just put this in here for the sake of completeness. It is a silent guarantee. It will always apply. So you don't have to discuss it. If Narisha buys my cell phone, she doesn't have to ask me, is it broken? Even if she didn't ask me, we didn't discuss whether it works or doesn't work, the guarantee against latent defects will apply. If I gave an express guarantee, I said to her, Narisha, I guarantee that it works perfectly. That is an express guarantee. Then if it doesn't, she will have a claim for damages. Will also apply if the seller acted fraudulently. Other words, if the seller knew about the defect and purposefully kept quiet about that. This will also amount to intentional misrepresentation. But I will always, if I give you a case study that is based on the seller's fraudulent action, I will specify in the question that if I want you to refer to the guarantee against latent defects, I will specify in the question, do not discuss fraudulent or intentional misrepresentation, just to give you a bit of a sort of a guideline, what I'm looking for. So acted fraudulently, knew. Don't confuse those two. They're not the same. I can give an express guarantee that the cell phone doesn't malfunction without actually knowing that there is something wrong with it. The express guarantee doesn't relate to my knowledge or a seller or not. It's about, I expressly said there's nothing wrong. Acted fraudulently goes a step further. That's where I actually knew, but decided to keep quiet. Disclose the defect. In these instances, the seller, these are your normal contractual remedies, actually. The seller can either cancel or uphold. So either cancel the contract or get their money back, or cancel the contract and get their money back, or decide to keep the thing and have a claim for damages. But damages only in those three instances. Otherwise, another possible remedy is cancellation and restitution. Cancellation and restitution means exactly what it says. Purchaser, oops, not the seller, purchaser. The purchaser can cancel the contract and get their money back. This is also not available in all instances. Cancellation and restitution is not available in the following instances. It will not be available if the defect is not that serious. For cancellation and restitution, the defect must go to the root of the contract, to the root of, so if it's of such a nature that a reasonable and careful purchaser would not have bought it, person would not have the thing. It must go to the root of a contract. So obviously it follows that if it doesn't go to the root of the contract, if it's not that serious, you will not have a claim for cancellation and restitution. If it cannot be cancellation and restitution, so you cancel, you give the thing back and you get your money back. If it can't be given back, then it's not capable of redelivery because it has been damaged by the purchaser. So be careful here. A latent defect is a defect that existed at the time of contracting. If the purchaser takes delivery, obviously you have to have taken delivery to realize that there is this defect. Then you realize there is a defect, but before you want to give it back, you don't look after it properly, and it gets further damaged and it can't be given back, then of course you won't have this claim. If you want to act in terms of the guarantee against latent defects and go for the remedy of cancellation and restitution, you have to do this quickly. You can't wait 6 months or whatever and then say, oh no, but I want to get my money back. Your claim for cancellation and restitution must happen as soon as possible after discovery of the actual defect. Sorry, if the purchaser knows about the defect, but despite this knowledge, exercises unequivocal acts of ownership. So an example of that would be Narisha has bought my car. Now she realizes there's a problem with the engine, and she offers it for sale to Snelda, but Snelda doesn't accept the offer. And now suddenly Narisha wants to come back and say, oh no, but cancellation and restitution, give me my money, take it back and give me my money back. If you've treated the thing like your own, subsequent to discovery of the defect, you will no longer have a claim for cancellation and restitution. So now you might ask, what now? I've told you that damages, claim for damages, you can only get in certain instances. And then I told you, well, cancellation and restitution, you can also only get in certain instances. What about if you bought something that has a latent defect and you don't fall into any of these categories that you can claim damages or you can cancel the contract, does that mean you have no remedy? Does the law desert you? No, it does not, because there's also a claim for price reduction. So you keep the thing, but you get some of your money back. You pay a lesser price for purchase. A seller has to refund a portion of the money so that you pay a fair price for what you bought. When is this available? This price reduction is available if the defect is that's not so serious to warrant the cancellation. So if you would have bought the thing, but not for the same price, so you would have bought it in any event, but you would have paid less. It is not available. If what you paid, if the thing is still worth more. So if you bought an absolute bargain and you subsequently find, but oh dear, there's something wrong with it. But even with the defect, it is still worth more than what you paid. Obviously, you can't get any money back. Now, when is this guarantee not available? We saw in all the previous duties that we looked at that there are certain instances when the guarantee will not be available. We'll just get to the correct spot in the notes here. So I'm jumping around a little bit. Guarantee against no latent defects will not be available. Firstly, if the defect so if you cannot prove these 5 requirements, you will not have a claim. Secondly, when will it not be available? If you have expressly agreed to exclude it. Remember what I said here when I started looking at these duties. Sorry, let me just find that. They will be always apply unless the parties expressly agree to exclude them. Now, similarly, you can agree to exclude the guarantee against latent defects. The term we use for if the defect is excluded is if it is a voetstoots sale. Voetstoots, that's not actually an Afrikaans word, that's actually Dutch. A voetstoots sale is where the thing is sold as is. As is. So with all defects. Most second-hand sales will be foot stewards. Foot steward sale is never implied. So if Narisha bought my cell phone and it has a defect, and she comes to me and says, well, it has a defect, I want some of my money back, I can't then say, oh no, but it was a second-hand phone, take it as it is, foot stewards. I have to inform her, and she has to agree at the time of contracting that this is a foot steward sale. So, Narisha, will you buy, are you interested in buying my phone for $1,000? She says, yes. I say, but remember, this is a foot steward sale. And she says, yes, I agree. But if it wasn't expressed, I cannot subsequently try to brush off a claim, claiming that, oh, it was secondhand, it's foot stewards. A foot steward sale is never implied, must be expressly agreed upon. So sold as is with all defects, there will be no claim for any latent defects. However, a foot steward sale will not protect the seller. So even if we have expressly agreed on a foot steward sale, I will not be protected under the following circumstances, namely, if I knew about the defect, but failed to disclose, so if I know there's a problem with my phone, but I just keep quiet about it, then, and I say to Larisha, no, foot stewards, please, I will not be protected by the foot stewards clause. And similarly, if I acted fraudulently, if I made so I told her it was perfect while I knew that it wasn't, then I will also not be. Interesting, to make it easier for you to remember, these two instances where the foot stewards clause will not protect the seller will also subsequently allow the purchaser to claim damages. Okay, any questions? Okay, so those are the duties of the seller. The duties of the purchaser appear in paragraph 5 on unit 51. I'm going to leave those for self-study. Remember, self-study does not mean ignore it and leave it out. Self-study means go through it yourself. But if I have left something for self-study, at most, the questions, if I assess you about that, It will be 1 or 2 point short questions or maybe multiple choice, that type of thing. It will not be assessed in depth. I won't ask a case study problem solving questions about that. So that concludes Unit 9 then. So we have completed the work that we need to do for your test. Do you have any questions?
No, ma'am.
Wonderful. Thank you, Narisha. So on Thursday, we will meet again. On Thursday, I will have a revision session with you because we have now completed the work that we need to do for the test. We have caught up nicely. I'm happy with our progress. Thursday will be a revision session. I'll go through the layout of the test, talk you through the requirements of how to answer case studies, give some general guidance. Revision does not mean that I am going to teach you everything again. You should have gone through the work before a revision class, so that if you have any questions, any queries, you can ask me during the revision class. If you don't have any questions, I'll give you some pointers, tell you what to focus on, layout of the test, etc., etc. That is on Thursday then. And then next week and Monday, we will not have a class. Oh, not Monday, Tuesday. Next week and Tuesday, we will not have a class because it's the late class. You can rather use that time then to study and prepare in order to be ready for your test then on Thursday, Thursday at 7 o'clock. Thank you so much. Thank you for joining the class.